16 minutes past 4 on the programme, and as we are commemorating Child Protection Week, we have in studio with us Advocacy Manager at Women and Men Against Child Abuse. And one of the issues we're going to look at is WMACA wanting to change a law so that anyone who witnesses a crime of physical abuse against a child is compelled to report it. Look, Lamprecht, thank you so much for joining us this afternoon. Lovely to have you on the programme.
Thanks, Joanne.
Can you start by just explaining to us what the law currently says about reporting physical abuse against children?
Absolutely. So in terms of the Children's Act, when children are deliberately neglected, sexually, physically abused and exploited, anyone who works with children, so they lay it out in terms of school principals, educators, people running children's homes, etc., they have to report it to a social worker or a police officer on the prescribed form, which is a Form 22, in terms of a particular regulation. So it only compels people who are in positions of employment in respect of children.
All right. So how does Women and Men Against Child Abuse want to change that law?
So there are a wide variety of amendments being proposed to the Children's Act. And one thing we're saying is why, in terms of Section 54 of the Sexual Offences Act, is sex offence anybody must report, knowing that a child is sexually abused. Why is physical abuse and deliberate neglect different to that? So what we're saying is very simply, and if we go to the Child Protection Week, over various years, it's the whole Ubuntu concept, is it takes a village to raise a child.
Yes.
And equally, it takes a village to ignore child abuse for children to get killed, like in the Baby Daniel case. So we're saying everybody has a duty to not harm children, and everybody, if they know a child has been abused, has a positive duty to protect children, not just because you're working with children. And the fact that we have to make a law to tell you should protect children, for me, is actually quite distressing, because it should actually be a gut thing that we all do.
We've in a way fallen behind with legislation in terms of protecting children in this country. Wouldn't you agree with that, Luke?
Absolutely. And I think what has happened is, even with the legislation, so this is only the first part of the challenge. So we've briefed Evershed's Sunderland attorneys, and they've come on board as our law clinic, and we've said to them, this is the first part. The first part is everyone must report. The second part, as in the Baby Daniel case, is that the people we are compelled to report to do not act. And that's where we get children getting killed. So
yes.
to use Baby Daniel as an example, many of his family members, by evidence given certainly in the sentencing in court, knew, including grandparents, that Baby Daniel was being physically abused and deliberately neglected. They did nothing. What then happened is over a period of 3 different hospital admissions, he ended up with a break in the top part of his leg, which the doctor said could not have occurred accidentally.
Yes.
So as per the Section 110, bearing in mind a whole lot of other people knew he was being abused who weren't doctors, so family members.
Yes.
And then what happened was the doctor said this cannot be accidental, referred it, like she's supposed to under Section 110, to the police and social workers. But because of the nature of the structure of both the social services and the police, the case went missing for a period of about 3 months. So this one didn't tell that one, and that one's not this jurisdiction. And, they just passed, literally passed the parcel.
Bureaucratic red tape. Yeah.
And what then happened was that systematically, he was, over a period of, according to the pathology evidence, he was systematically burned, tortured and beaten to death. And we ended up with a murder trial. Now, the authorities that the professionals are compelled to report to were indeed informed.
Yes.
And what is deeply concerning is the people that are now responsible for the younger siblings and where they go are the same people who were responsible for keeping Daniel safe, who did not intervene timelessly. And the thing I find most difficult about because you can only report to a designated child protection organization or social development and the police.
Yes.
And what I find deeply distressing about it is that those social workers and police, they overrode the doctor's evidence. So instead of bringing the matter before a court, as they should, a criminal court and the children's court, what they did is they phoned or went to visit and said, everything looks fine, we're going away. So the state organs that are charged with, once we've reported it, we are now taking on in a legal matter with the lawyers to say the fact that you didn't act directly led to the death of this boy, because the doctor discharged her duty. And in fact, we're going back a step and saying, if the grandparents had discharged their duty, he wouldn't be dead.
Yes, yes. So there are two parties that you're looking at,
Correct.
essentially, in this litigation. I want to focus for a moment on the existing social work system. I mean, clearly, these individuals have gone through a certain level of training. One assumes they're trained for a particular situation in our country where child abuse rates are extremely high. What is it that you think might have prevented them from actually following through with the doctor's hunch on what was happening with baby Daniel?
So the first thing is that the delineation of powers within government create a problem. So let's take each department separately. So health has a doctor. That doctor is compelled to report. That doctor reports to the social workers at health.
Yes.
Health doesn't have designation to do child protective services. So they have to refer to the Department of Social Development. The Department of Social Development, in turn, has outsourced child protection, certainly in this particular jurisdiction we're talking about, to non-profit organizations,
Yes.
run child welfares and church welfares.
Private organizations.
Yeah, NGO organizations,
Yes.
and then they are designated with power. So
Right.
you only have access to that organization within that jurisdiction. Then in terms of the police, you go to station level. At station level, you have got your local police officer who knows absolutely nothing about how to register child protection cases. And what happens is once the case is there, and I'm talking about these kind of cases where there's
Yes.
intense medical evidence, they have no idea. What happens is it then needs to be referred to the Family, Child and Sexual Offences Unit, which is a cluster competency. So there's a cluster, so you've got about 10, 12 police stations that then are the detectives from the CPU or the FCS come and they
Yes.
investigate the case. Within that structure, if the child dies, the child gets moved out of the Family, Child and Sexual Offences Unit as an investigator back at station level because now it's an inquest docket and the FCS don't investigate child deaths. Mm-hmm. So the ability to fall through the cracks of the system is just enormous because it's literally like pass the parcel, as I said earlier, from one department to the next. And all of that is paperwork and all of that is needing to get the right designated people. And the average person on the street doesn't know how to access those. And once
Yes.
it's in that system, that's a problem. And then the fact that regardless of their training, and I think there's varying levels of expertise in those, in DSD and the police, they should not be in any position to make a decision to override a doctor's finding.
Yes, absolutely.
And that, for me, they acted outside of their sphere of knowledge and influence, regardless of their training.
But isn't this in itself a disturbing trend that the state outsources social service functions, social work functions?
It's a function of the previous apartheid dispensation where what happened was the separation of church and state became an interesting thing. So what happened is you had people, so within the white social services, or everybody got nice social services. And then what happened when you had the traditional sort of black services, they were now run by welfare organizations. They used to go and deliver kospakis and used to go and do nice social services.
Yes.
And when the state then, when we did the the Children's Act, within the Children's Act, what happened is we had designation and the state didn't take back the protection services from these particular agencies. Mm-hmm. So they then subsidized them and technically have oversight. What does need to be pointed out, though, is that the state still has responsibility.
Yes.
Because you can't designate away your designated responsibility.
Right.
Because you still should be overseeing it. And that's where we are.
How well is it overseeing it?
Well, I don't think it's overseen at all, to be frank. The monitoring and evaluation that I've been party to is, have you got the correct amount of stats? Is your demographics correct? Have you spent your grant on what you're supposed to do? You have a social worker employed in the position you are getting a grant for, etc. It's not, there's not an adequate monitoring, and particularly of these very high index of suspicion cases. If a pediatrician says to you, there is a problem, why would you second guess the pediatrician? If you took your own child to a pediatrician and they made a diagnosis, would you second guess them? I think not.
Yeah. I have to ask you one last question, Luke. It's an important one about juvenile programs, because we're getting examples of a number of cases where older children harm younger children.
Oh, sure.
How is the government dealing with that?
So the law in terms so that's the Child Justice Act, the Freudian slip. You know, when you say one thing and mean your mother, you know, the Freudian slip around the Children's Act and the Child Justice Act is the fact that the government the law is absolutely phenomenal, and the possibilities around diversion programs are exceptional. The problem we are having is primarily at point of entry. So we are getting situations where the police, so you'll present as a child who's an accused to the police, and the police don't want to take the case on because the child is a child and they don't want to process the case.
Yes.
Because they have a mandate to decrease crime statistics.
Oh, right.
So the easy way to do is to refer it away. I mean, I see this in Alex all the time. Mm-hmm. So whoever from government is saying I'm talking rubbish, I'll take you to Alex and I'll show you that I've got a database of these cases. And then what happens is because they don't get processed through the formal criminal justice system, we can't get them processed under the Child Justice Act. So in other words, there's no mechanism that we can get to actually compel them to attend the programs which are of a diversionary nature, and there's some very good ones. I mean, the Teddy Bear Clinic runs one that I was involved in. Sanka, Nikro, Kulisa. I mean, there's lots of great programs, and I think there is such a missed opportunity that when children present in conflict with the law, that we don't. The aim of the law is not to act punitively towards children. The aim of law is to open a basket of services to the children to assist them where their development has been impaired and their behavior criminally shows that we as adults have not raised them properly.
All right. Look, this is a very lengthy conversation because, of course, this is going to go through the courts and we're going to be unpacking it bit by bit over the course of Child Protection Week. Thank you so much for getting our discussions on this important issue kick-started.
Thank you for having me.
Luke Lamprecht, advocate.